In addition to the opinion of the court, Justices Thomas and Jackson offered concurring opinions. Justice Thomas started with, Deborah Lawfer has filed hundreds of lawsuits against hotels she has no intentions of visiting, claiming their websites lack accessibility information mandated by a federal regulation. At both parties' requests, this court agreed to answer a question that has divided the courts of appeal, whether plaintiffs like Lawfer have standing to bring these claims. The court decides not to decide the question because, after the briefing began, Lawfer voluntarily dismissed her claim in the district court. I would answer this important and recurring question, which, as all agree, we have the authority to do, and I conclude that Lawfer lacks standing. Justice Thomas noted that the court agreed it has the authority to decide if Ms. Lawfer, along with plaintiffs like her, have standing to sue. The court decided to punt on that question simply because Ms. Lawfer voluntarily dismissed her claim against Atchison Hotels. In Justice Thomas's opinion, Ms. Lawfer lacks the standing necessary to pursue such litigation. The district court concluded that Lawfer lacked standing and dismissed her complaint. The First Circuit reversed, relying primarily on this court's holding in Havens Realty Corp. Versus Coleman, that a tester had standing to sue under the Fair Housing Act. Lawfer lacks standing because her claim does not assert a violation of a right under the ADA, much less a violation of her rights. Her claim alleges that Atchison Hotels violated the ADA by failing to include on its website the accessibility information that the reservation rule requires. Yet the ADA provides that no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the services of any place of public accommodation. In other words, the ADA prohibits only discrimination based on disability. It does not create a right to information. While agreeing that the case was moot, Justice Jackson disagreed with the other part of the opinion of the court. I agree with the court that this case is moot and that it should be resolved on that basis. But the court goes farther, ordering vacature of the judgment of the Court of Appeals under United States versus Mussingware. In my view, when mootness ends an appeal, the question of what to do with the lower court's judgment, if anything, raises a separate issue that must be addressed separately. In Justice Jackson's view, the question of vacating the opinion of the First Circuit Court was not decided as a separate fact.